Am I reading Mandarin? I mean, the device says that you're drinking.
That was hand sanitizer at my job. I lose my job.
Confusion right at the start. She's basically saying, this doesn't make sense. And that's your hook. But here's the real question. Is the system about to rely on a machine over her word?
I lose my apartment, I lose my kids, might end up having a miscarriage because I'm in there for 45 days for something that I did not promise.
She's consuming alcohol while she's while pregnant.
How?
You're 5 months pregnant. You have positive alcohol usage on August 3rd.
No.
Am I reading Mandarin? I mean,
That's
right?
according to the device. Yes, sir.
The device says that you're drinking.
That was hand sanitizer at my job, which I emailed my probation officer that day. It's not alcohol. That's why they took me out the register and put me on the floor to where I won't be around anything that consume alcohol, which is the hand sanitizer at my job. And I let my probation officer know.
Sanitizer dissipates in a matter of a second. Once you put it on and you're done like this, it dissipates in a matter of seconds.
But they write down all the registers and stuff. I have not consumed any alcohol at all.
That's what this report says. Not only does this report say that you're consuming alcohol, you have excessive skips while you're on probation as well. Your
Honor.
Hold on a second. Hold on. Okay, so April 4th, skip test. April 16th, skip test. April 18th, skip test. April 24th, skip test. April 25th, skip test. April 29th, May 2nd, May 15th, May 19th, May 22nd, June 2nd, June 4th, June 8th, June 9th, June 13th, June 16th, June 23rd.
Now this is where things shift. One questionable result is one thing, but a long list of missed tests? That creates a pattern. And in court, patterns speak louder than explanations.
3rd, June 25th, June 26th, June 30th, July 2nd, 5th, 11th, 12th, 13th, 15th, 16th, 18th, and it goes on and it goes on as the day is long.
I was here on the 11th. I seen you on the 11th. We had court. And I said I work at the register, and I explained to my manager that I had to step away from the register to blow into my device. So as soon as they understood that I'm on a case to where I had to step away from the register, then they had allowed to me, because I have 3 hours of window to blow into my device. So I had got that handled, which I told my probation officer as well. So I allowed my manager to understand to where I could keep my job, to where she can move me to a different department to where I won't keep leaving from the register to go blow into my device, so I will not be late.
Not only are you allegedly skipping, not only are you allegedly consuming alcohol, but you also have a prior DWI, felony DWI with a child from a year and a half ago.
Drug test, and I passed all my drug tests, so I'm just impossible, because I have, and you can go to, and they took my blood test and my doctors as well too, so I have not consumed any alcohol during my pregnancy or before my pregnancy. And when I stood before you on July 11th, I have not took any alcohol at all. That's the honest truth. And I saw you on the July 11th, and then after that, when I had found out I was pregnant, they took my blood and everything. I have not consumed any liquid of alcohol down my throat.
We have clinicians that evaluate you to determine what the best course of action going forward on this probation is. They've deemed, after doing all their research, that the best way moving forward is to put you into a residential treatment program. I like to follow the advice of the clinicians because they know what they're talking about. Not only, are they saying this, but you're also providing us with evidence as to why it's a good idea. You're saying you're not consuming, but I have concrete evidence that you are, and I have.
This is the emotional peak. She's not arguing evidence anymore. She's talking about consequences. Real-life fallout. So ask yourself, if there's even a chance she's right, is this risk worth taking?
Dozens of skip tests when you're not supposed to be skipping.
I know. They said I consume alcohol, because that's the day that I emailed my lawyer that day, and I was at work.
It's not a negotiation. that's what they're recommending, and I think that it's a good idea. You know,
So that means I go 45 days, I mean, I lose my job, I lose my apartment, I lose my kids, might end up having a miscarriage because I'm in there for 45 days for something that I did not do. That's the reason why I'm back, because I have not.
So just the only other thing I could offer is maybe Santa Maria. Have the clinicians considered that? Did they know she was pregnant?
The recommendation was a community residential program followed by social work.
They didn't recommend Santa Maria. Did they know she was pregnant?
what's the difference of Santa Maria versus?
It's an outpatient drug residential facility treatment center for pregnant females. It's only pregnant females. She can get a bed there reserved for her, but they have to accept her into the program. It's common in felony with pregnant women, but I don't know what it's like here in misdemeanor if they even offer the Santa Maria hostel. But it's supposed to help pregnant women.
Are you married?
No.
Who's taking care of the other kids?
Me.
You don't have any other person in your life?
Boyfriend, but I mean.
Okay, so you currently live with your boyfriend.
Mhm.
So he's got, possession of the apartment, I would imagine as well. So you're not going to lose your apartment.
Apartment's in my name, not his.
Okay. I mean, as long as the rent is being paid, but my concern is that you're not consuming alcohol, especially while pregnant, because if you do, you're ensuring a lifelong potential problem with that child. I have evidence here that you're consuming alcohol. I have evidence here that you're refusing to blow into the machine like you're supposed to. And that's why we do these. Recommend.
I'm so sorry.
I know that you don't like it, but I'm sorry.
No, because I can't just stand here and just, I can understand the skill part, but the actually drinking alcohol, I can't stand here. And that's on everything I love. I have not consumed any alcohol since you put me on probation. Since we had this last conversation, I have not put a risk.
To prove to you otherwise.
Germans have alcohol in there. So it's like y'all saying that I actually took a cup. I actually put it to my mouth and I actually drunk the alcohol while I'm pregnant. I can't stand here and let that go by and feel like that's okay. Because I knew I have not. And I emailed my probation officer when it happened, when it violated on my device. I'm just national guy. I'm sorry. I'm just trying to get him to understand.
I understand that you're upset.
I literally emailed her when the device was violated. When it said violation. I was at work on lunch trying to catch it before 8 o'clock. And that's when it said violation. So I'm trying to figure out, we have hand sanitizer everywhere on the registers. So that's where it came from. It have not come from no alcohol.
It's not hand sanitizer.
Here's the judge's philosophy. You had your chance, now it's my way. This isn't just about this case anymore. It's about control, compliance, and accountability. But is there still room for doubt?
Hand sanitizer doesn't go into the actual tube that you blow into. I mean,
Your
I'm
Honor,
sorry if you.
Your Honor, would you consider if she meets the requirements for this Santa Maria outpatient?
Of course.
Would you be able to?
Outpatient?
Yes, Your Honor. In light of the fact,
she's been on probation. We've given her the opportunity to do it on her own, and you're not doing it. So that's why we have this now as the alternative. And I always tell everybody, look, I will give you the opportunity to try it yourself. If you're unable to do it, then we're going to do it my way. And I know that you're not going to like it, but that's the reality. The reality is that we don't want you to consume alcohol, especially while you're pregnant. And I've got evidence to the otherwise. And so the only way is to do it our way. I know you don't like it, and I'm sorry, but that's the reality.
Your Honor, if I may, can I have the date that you say that she tested positive for?
Here, I'll give everything to you. If you want more time to take a look at it, just you guys hang tight, go take a look, and we can come back up here and talk. Don't leave. Otherwise, I'm going to. If you pick up a fourth case, holy moly, I'm going to absolutely lose it. Do you understand? I want my community safe. When you're out there, you need to make the right decisions before you do something think if I do this, what's going to happen? If I say this, what's going to happen? And if it could lead to a bad result, then don't do it. Do you understand? Can you run his license to see, does he have a valid?
Eligible, Your Honor.
Okay. You're not allowed to drive unless you have liability insurance as well. Do you understand? If you don't have car insurance, you cannot drive as well at all until you have a license and car insurance. Do you understand? Okay. Do we have any conditions, on the terroristic threat?
Judge, I got assigned to him, he was already in the back.
Correct.
And so I don't know if there was anything in the previous case. I know one of them is against the brother. My understanding that I think.
So I guess tell me about it, Alex, please, on both terroristic threats. Who are they?
Terroristic threats? Yes, Judge. So on the first terroristic threat, the complainant and the defendant are brothers. Dispatched to a residence in regard to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the vehicle, and the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this, and the defendant also later texted the complainant that if he touched his things again, he would cause him severe pain.
This is the second one.
And the second terroristic threat occurred on October 26, 2024, when the officer was dispatched to a Crunch Fitness. The officer made contact with the complainant, a manager at the gym, who stated the defendant was involved in verbal and physical altercations with other members of the gym, and multiple complaints were filed. The complainant stated the defendant's membership was canceled due to issues with other members and the defendant making threats.
Now we're in a completely different situation, but same courtroom energy. Alleged threats. And legally, even saying, "I'm going to come back and kill you," can be enough. The question is, does intent matter, or just the words?
The defendant then continued to act aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, returned multiple times, and when the complainant stepped out with the defendant and told the defendant not to return, the defendant responded multiple times he was going to come back to the business and kill the complainant.
Judge, I would argue on that one. I'm going to come back. I don't see an immediate threat or anything like that, any brandishing of anything. Or...
You're right. It's the going to that.
They say, repeat what the threat was again.
He responded multiple times he was going to come back to the business and kill the complainant.
I'm gonna come back, I think that there's enough to go forward. Don't go back to these places. I don't want you to have contact with either of the complaining witnesses. Do you understand? I'm gonna have you sign these bond conditions. Make better decisions when you're out there, Mr. Jenkins. At some point, someone is gonna stop bonding you out, and you will be stuck like Chuck in there until these things are over with, and it's gonna be a long time. Do you understand? You've asked me to give you a different lawyer. This isn't Burger King where you get your way. I will not give you another one. If you're unable to get along with Mr. Perez, then probably not him. Do you understand?
Yes, sir.
He may tell you things just because you don't like it. It doesn't give you a cause to complain and I don't like this person. No, he's going to give it to you. I've worked with him for many, many years. I trust him. He does a good job. That's why we gave him to you. You understand? Okay. So we'll have you sign these bond conditions, and after that, you'll be free to go. So he was not, I guess, having a good time with the prior lawyer.
Sure.
So,
I've spoken with his mom already over the weekend.
okay.
We had a really good talk about what was going on. I didn't know she was going to bond him out as soon as she did. So we're about to go have a talk with the factory about it.
My guess is, though, is that if it's mom, she's not going to continue to do it because every time she bonds you out, all you're doing is you're giving free money to bonding companies. When you pick up new cases, all you're doing is you're giving money away. And I'm sure your mom doesn't have unlimited funds to just keep putting money away. Get a clue. What do you do for a living?
I worked for Uber because the job I was doing.
No, I just want to know, are you fully employed?
No, not at the moment.
You need to get a job. You have too much time on your hands and you become self-destructive.
It's hard to get a job because of my resume.
Just listen to people.
It should tell you something. Do you think it gets easier in life? No. You don't even have convictions and it's hard for you to find a job. How hard do you think it's going to be if they end up in convictions? Do you see my point?
Sure.
Make better decisions. 95% people are in there because no self-control. All right, Matt.
And Your Honor, on both the Treasury Fair cases, there are previous conditions from.
Yeah, I will just have them sign those.
Okay.
Yeah. So Matt, these are state's bond conditions, so they've already been filed. All you need to do is sign them. Mr. Hernandez, you're charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 19, 2025, at approximately 11:17 p.m., the officer was dispatched to a discharge of a firearm call on Tilbury Woods Lane. Multiple calls stated there were multiple gunshots in the area, and while servicing the area, the officers were flagged down by a citizen who stated she heard multiple gunshots and a green sedan sped off. Multiple citizens provided video footage, and the officer saw a vehicle that matched the description parked illegally in front of a residence on Moss Springs Court Road, and multiple males exited the vehicle. The officer then initiated a traffic stop, and the driver and passengers began evading on foot. Officer ran after all three males for 100 yards, and all were detained by the officer. The defendant and others admitted they saw emergency equipment and decided to evade on foot.
And this is the bigger picture moment. Different defendant, same message. Your decisions stack up fast. One mistake turns into a record, and that record follows you. So the real question is, where does it stop?
Surveillance video showed the defendant throwing an AR pistol with no serial number in front of the residence, and surveillance video matched the defendant's clothing.
Saying our defendant here was seen throwing an AR?
Allow me to read the DIM to confirm that it is.
Sure. They filed a tampering. Am I right in assuming that that's the serial number?
Yes, Judge, it is this defendant throwing the AR, and the firearm had no serial number. Yes.
How can you impute the tampering because it's a specific intent crime, right? Unless you have an admission or something like that. Something that I have. But you know what? That's not even my forte. It's like we're doing the evading right here. So
Fighting upstairs, gonna
I
fight
gotcha.
down here too. So you can already expect my issues with this case already.
you know, you're 17, you're now starting your life. This is not a good way to start. You know, you only have two ways that you can go. You can go up or you can go down. Life doesn't get easier the older you get. It only gets more difficult. You get bigger, fatter, you lose hair. It doesn't get easier. And it starts with school. Stay in school. Don't hang with dogs. You're going to get fleas. Do you understand? Mr. Hernandez, you are not to smoke weed. You're not to use alcohol. And I'm making that a condition of your bond. I don't want you to have any possession of any weapons as well. Do you understand? If I find that you're in possession of a weapon, I'm going to revoke your bond. I'm going to put you in jail. You're going to finish school with me. You understand? Did they impose any other kind of restrictions up there as far as like curfew or anything like that?
They did not. At first, he had an ankle monitor with a curfew. I asked the court, they agreed to take it off. So his mother and him are going to go after this court proceeding to get that removed.
Is mom here?
Mom is here outside with his younger sister.
Okay. Make good decisions, man. Once you start racking up convictions, I'm telling you, it's over. It's not going to get easier. You understand? We've given you a lawyer. It is your responsibility to stay in touch with her. She's great. She will help you out. If you're not listening to her, you take off. I can't find you. You pick up a new case. I'm going to put you in jail. No more PR bonds for you. Do you understand? One more thing. I will test you in about 45 to 50 days. And if I find that you're smoking weed, it's not going to go well for you. Do you understand? You will get tested. Be ready. So I don't care what you're doing. If you stop using, if you stop doing anything that you shouldn't be doing now, then you should be fine in 45 to 50 days. But if you continue to use, or if you smoke, it's not going to go well. You understand? Okay.
Thank you.
Thank you so much for coming. We got you. And then anything you need, whatever you need, just come back and we're happy to help.
Thank you, Judge. And just one thing real quick. I know there's other people that were in this vehicle allegedly. Do you have any names for them? Can you,
I can see.
if I circle back around from you?
Oh, co-defendants? That's a good, because you know what?
And that's part of my issue with both of these cases.
And Your Honor, it does not appear there's any connected cases.
So I have,
So
yeah, that's my issue with the tampering. That's my issue with this case.
They got them all, right?
That's what they say.
Maybe just because of the surveillance shows allegedly one being thrown and that's why they only went after. Perhaps, I don't know. But
I won't fight everybody too crazy today, but probably the next day. Yeah.
I'm with you. You know,
Yes.
whatever you need, just
Thank you, guys.
make good decisions. That's all we're asking you to do. All right? Okay,
you very
guys.
much.
Thanks. You got it. Mr. Venegas, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. I have previously found probable cause on this case. I'm ordering you now as a condition of your bond not to participate in like-kind activity. If I find that you're racing, reckless driving, acting a fool on the highway, number one, I'm going to revoke your bond, put you in jail. The second thing is I'm going to take away your privilege to drive. Do you understand?
Yes, Your Honor.
Do you see if he has a license?
still running it, Your Honor. For some reason, it's slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest. You pick up a new case, act a fool in the free world, I'm going to take it away.
I'm able to run it right now, Your Honor. It's not letting me on our system.
So can you file the same conditions on the racing that we
Same racing conditions, yes, Judge.
All right, so I'm going to have you sign a reset. After that, we'll have you take a seat in the jury box. We'll get your bond conditions. You have to sign it, and after that, you'll be free to go.
Good morning, Your Honor. Morning. Wanted to approach on behalf of Chaston Blackburn regarding probable cause. I have issues with probable cause in this case, Your Honor.
Okay, let's do it.
So officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filter sobriety were conducted, HGN 4 out of 6, walk and print 4 out of 8, one leg stand 2 out of 4. DICs were read and the defendant consented to breath. The results were .086 and .084.
Your Honor, when you turn on the video and it's between,
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety test being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video for 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise, we can set it. But, when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond to that. I can't just rule on it, whether,